This was a big mistake, and I think that this doesn't represent him.
A father is accused of leaving his 2-year-old toddler in a hot car asleep, and she dies. Why did this happen? He's charged with murder. What's his defense? And by the way, this apparently isn't the first time he's done this either. Did he just forget she was out there, or did something else happen? Arizona attorney Aaron Reed will help us understand this very, very tragic case. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. It was around 1 p.m. on July 9th in Marana, Arizona. 37-year-old Christopher Scholtes was running some errands with his 2-year-old daughter, Parker. Let me emphasize that again. I want you to remember that age. 2 years old. And like many children, she'd apparently dozed off in her car seat in the back. And when he pulled up to the house, he claims he decided to leave the air conditioning on and let her nap. So he reportedly goes into the house, and according to his other children, he, quote, got distracted by playing his game and putting his food away. We're talking, by the way, about a PlayStation, the gaming console. So what happened to Parker? Well, the car that she was in was parked in direct sunlight, temperatures hitting a record-setting 111 degrees that day. According to the National Weather Service, it would take about 20 minutes for a car to heat up to 140 degrees and 40 minutes to reach 150 degrees. Well, over the next 3 hours, a neighbor's video surveillance camera reportedly showed that Mr. Scholtes didn't check on his daughter once. In fact, he allegedly forgot he'd left her in the car. Because when his wife, 35-year-old Erica Scholtes, came home from her job as an anesthesiologist at about 4 p.m., she asked, "Where's Parker?" So her husband reportedly began checking the rooms in the house and then realized he'd left Parker in the car. He went out to check, found the car wasn't running anymore. His daughter was in her car seat, unresponsive. Erica apparently raced outside, performed CPR on the toddler. First responders arrive, but it was too late. Parker was pronounced dead at the hospital, 2 years old. Police, they searched the house, they took the PlayStation, they found some other electronics as part of this investigation, along with the car, of course, in which Parker died. They also interviewed the other children, by the way, ages 9 and 5, and they told police their dad had often left all 3 of them alone in the car. And there were text messages, by the way, between the parents that we saw. This was as their daughter was on the way to the hospital and apparently backed up what happened. We're going to get into those text messages in a minute. But shockingly, Scholtes even allegedly admitted that he knew from previous experiences that his vehicle had a safety feature that turned off the engine after 30 minutes. Christopher Scholtes was arrested by police. He was charged with second-degree murder and child abuse. That is what he's facing. In a virtual court hearing, he pled not guilty. And then his wife, Erica, talked to the judge where, and this was astonishing, she made a heartfelt plea to let her husband come home while awaiting his preliminary hearing on August 1st.
So I'm just asking if you can allow him to come home to us so we can all start the grieving process so that he can bury our daughter with us this upcoming week and that we can go through this whole process together as a family. This was a big mistake, and I think that this doesn't represent him. And I just want the girls to see their father so that I don't have to tell them tonight that they're going to endure another loss.
Now, outside of a DUI charge from about 15 years ago, Scholtes does not appear to have a criminal record, so the judge set a $25,000 secured bond, refusing the state's request for a heftier $1 million. But one of the conditions of Scholtes' release was that he cannot have unsupervised contact with children. And a police news report reads, "This incident is a stark reminder of the dangers of leaving children unattended in vehicles. The temperature inside a vehicle can rise rapidly, even on relatively mild days, leading to potentially fatal outcomes within minutes." Now, I want to welcome on Arizona attorney Aaron Reed to talk about what is just an absolutely horrific and tragic case. Aaron, thank you so much for coming on. Let me start with this. According to the National Highway Safety Administration in the United States, about 40 children a year die from heat stroke in cars. That's one child every 10 days. So Why are so many people leaving their children in cars? Is it that they have busy lives? They get distracted? Is it intentional? What do we see?
I think it's probably a combination of all of those things, but 40 children a year, that's 40 too many. These are all preventable circumstances. These are all things that should never happen. They're children. You're a parent. Be a parent and take your kids out of the car. I know sometimes they're sleeping, or sometimes it might be crying, or sometimes it might be better to easier for you to keep them in the car. That doesn't mean you should. You're their parent. You know what's best for them. You need to be the person that prevents this. So I think it's probably a combination of all of those things. Intentionally, we don't really see that happening too much, although most people can probably argue that doing this kind of thing has some sort of intent to it.
Now, we will get to that legal aspect, and there's a lot to get into with the legal aspect. But you're from Arizona. You live in Arizona. In New York, we're facing some really hot heat here in New York City, but that is nothing compared to what you're feeling in Arizona. So just tell us, if you can, what is it like, those heat waves? What is that temperature like? Just so we can all understand what we're talking about when we say a 2-year-old was left in a car.
So just the other day here, it reached, I think, 118 here in the valley, Phoenix Valley. And it is, when you go outside, it just feels like when you open the door of the oven and that kind of hits you in the face. It feels like that, but it's constant, it's consistent, it's over and over again. And you don't want to be outside. The first thing you want to do is get to where you're going and get inside because it's so hot, even for adults. We see adults that go on hiking trails here in Arizona that die every year of heat stroke, and they're adults. They bring water. There are things that they're prepared for that kind of thing, and they still pass away, let alone a child who has no ability to prepare for this kind of thing, and they're at the whim of their parents.
Yeah, I can't really like hide it very well, but these are the toughest cases for me to cover, and it's that idea of helplessness. I mean, especially in a situation like this, there was no way for her to escape, and hearing those temperatures is just really, it's tough to visualize that. But focusing on the law for a second, so Christopher Scholtes, so he's charged with second-degree murder and child abuse. Talk to me about what second-degree murder means in Arizona. Do you think that murder charge is justified here?
So in Arizona, there's three different ways that a person can be charged with second degree murder. Obviously, everyone knows first degree murder, it's an intentional killing with premeditation. Arizona has an intentional killing without premeditation, which I don't believe is what the state is trying to use in this situation. Another way is knowing that the person's conduct will cause the death of a person, engages in that conduct, and the person actually dies. That is possible, but I think the third way is going to be the strongest that the state has, and that's that has under circumstances that manifest extreme indifference to human life, a person recklessly engages in conduct that would cause the death of a person and death ensued. So I think in this situation, leaving your 2-year-old in a running vehicle, knowing that it's going to turn off after 30 minutes, at a minimum, rises to a level of extreme indifference to human life, knowing that they're a 2-year-old, they can't get out of their car seat, they can't open the door for themselves to get out if they need to. I think that's where the state would probably try to prosecute them under. And it sounds like they'll have a pretty substantial case with other evidence that we have out there.
And when you talk about other evidence, I'm assuming you mean the text messages, which are just kind of horrifying to think about because Scholtes' wife had texted him, "I told you to stop leaving them in the car. How many times have I told you we've lost her? She was perfect." And Scholtes apparently writes back, "Babe, our family, how could I do this? I killed our baby. This can't be real." What do you take away from that in terms of prosecuting this case?
First and foremost, as a father, I mean, it's absolutely gut wrenching to see and hear text messages like that. It's just it blows my mind. But as a prosecutor, they're going to look at that as extremely strong evidence of a pattern of behavior, a pattern that he knew about, that the wife knew about, and they didn't correct. And now the ultimate price was paid with the death of their 2-year-old daughter. So I think that is going to be strong evidence that a prosecutor will use to have a timeline of different events and also to show the jury that this is not a one-off. This is not something that was a mistake. This is something that he knew about and was warned by his doctor wife. His wife is a doctor. and still didn't bother to heed her advice and just ignored everybody and did it at his own pace because of I wanted to play PlayStation, or he wanted to go clean the house or do something and didn't want to disturb his 2-year-old child. I think it's going to be a very strong piece of evidence, that text message and the other pieces that they have.
Let me ask you a question. So you mentioned there are 3 different theories by which you could get second-degree murder. Depending upon which way prosecutors argue the case, whether they say it was someone engaging in reckless conduct or somebody knows that they're doing something that could create death or serious physical injury, or intentionally killing, does that change which way, depending upon which one they argue, does that change the punishment? Because what my understanding is, second-degree murder carries 10 to 25 years in prison, and correct me if I'm wrong on that, but depending upon what they argue, does that change what the punishment can be if he's found guilty?
That's a great question. And the answer to that is no, it doesn't. So if they can convict him under any of those 3 subsections of that specific statute, then it carries with it a conviction for second degree murder, which triggers the 10 to 25 year range. Now, at sentencing, if a judge has the full range of sentencing to look at, that judge can consider whether it was reckless and whether it was intentional, and go and weigh and balance that when finding a year that their person's going to be sentenced to. So I think if it was more of a reckless thing, a judge might be more inclined to go down to the lower end of the range. If they did show that it was some sort of an intentional killing, the judge might be more inclined to go to the higher end of the range. That's probably something that prosecutors would argue. But that is a great question. It does not change the outcome. If he is found guilty, it doesn't change the range of punishments that he's looking at.
What on earth can be a possible defense here if those are the 3 categories? You might be able to say, if it was only intentional, right? You could say he didn't intend to kill his daughter. I mean, I'm sure there's a way to defend that, but this is, I don't know, based on these facts, what's more reckless than this?
I was thinking about this question, reading through this case. What would a lawyer do? How would you defend this? And that's kind of what a lot of defense lawyers do when they read things like this. But this is one where you would have to really get creative. Maybe he has some mental health issues that prevented him from understanding what was going on, or prevented him from understanding advice, or not, knowing the gravity of the situation. That could also always be looked at in homicides and cases where there's death. But as far as any sort of justifications or accidents, something like that's going to be something that a jury's not going to buy. So as a 2-year-old, you know that they're in the car, you know where you left them, to sit there and come back and say, oh my God, I forgot. That's not a defense. So I think they're going to have to use some sort of angle, maybe mental health issue that they can bring up. But I suspect that a prosecutor, that a defense attorney would likely try to plead this case out as best as they can.
And I was going to ask you if a plea deal should be on the table here. And listen to what I said, should be on the table. Why do I say that?
Right.
This is a tough case for me to even talk about. Imagine having a jury sitting through this and seeing the autopsy photos and hearing this. So I would imagine sparing everybody what the details of this case are, instead of having to potentially force young children to testify about their father leaving them in the car, and the time and expense of a trial. Do you think a plea deal would be possible in a case like this, even though we are talking about the death of a 2-year-old that should not have happened?
I think in most cases, plea agreements are possible. Anytime you have a death, it's kind of reversed from what we normally see it on our end. And in most cases, you kind of get a plea agreement, you can negotiate and try to figure out a resolution. But on death cases, a lot of the times prosecutors will not offer them, and you have to provide them with information as to why they should offer one. That's probably what I would do if I was in the prosecution's shoes, because I understand you don't want to put the family through a difficult trial. Those children testifying could be extremely difficult for them, but you also have to have deterrence as a prosecutor. You have to be able to look at a case and point and say, look, this is what our standard is. If you guys are going to engage in this kind of conduct, this is what's going to happen to you. So don't do this kind of thing. I think there has to be some deterrence because, like you pointed it out earlier, 40 children a year, that's just 40 too many. That's a lot of children that are passing away from something that is senseless and stupid.
I, I hate to ask this question. I have to ask this question. Based on the text message allegedly sent by Erica Scholtes, does she open herself up to any liability that she apparently knew her husband had been leaving the kids, or at least her daughter, in the car before, and look what happened. Look what the allegation is here. Look, he is innocent until proven guilty, but we talk about the evidence. But again, I think does that open up herself to any kind of liability?
I don't think it'll open her up to any criminal liability. Certainly, when you look at Department of Child Safety, DCS investigations, those kinds of things, whenever there's children involved, DCS will be involved investigating that on their end. So there might be something where DCS could theoretically step in, but I don't know if she'll be charged. I think there is a way to charge her with some sort of crime for placing her children in those kinds of situations, knowing that her husband had done that in the past. Will they charge her? Probably not, because I think the prosecution would rather use her as a witness if they can. I know there's some marital and spousal privileges and things like that that might kick in, but I think they would rather try to use her as a witness than prosecute her.
And to be very clear, no one's advocating for her to be criminally charged here. But when I read that message, it was something that came into my mind about, this idea of knowing that he had done this in the past, and the kids saying, or allegedly saying this as well. But there was that part, right, where she was pleading with the court to let her husband come home so he could grieve with the family. And you think about the rest of his children potentially without their father. What did you make of that? Which again, the allegation is he was responsible for the death of one of their children, and yet she's asking the court, please let him come home.
I think that she's an extremely strong woman. I think to be able to have that kind of courage to go into court, knowing that her 2-year-old daughter just passed away because of something her husband did. I think that's an impossible situation for most people to understand and be in. And I think her being there was a way of showing the court that, yes, he did do something wrong. He's alleged to have been committed this crime, but he's also the father of my other 2 children. I want him home. I need him home. And he deserves to grieve with with all of us. I think that just shows her true character of being just a really tough, strong-willed woman to be able to do those kinds of things and have these tugging, different emotions pulling at her. I think it shows a lot of strength.
And she told the court, Erica Scholtes, that she's going to have to take an extended leave of absence from work to take care of her other children, help this family heal. So again, with him not being around, this puts an extra emphasis on her. Our hearts and our prayers go out to that family. It's a tragic thing to think about, but as we talked about, it happens so much. But this is just another example of an incredibly sad case that should not have happened. Aaron Reed, thank you so much for coming on. Appreciate you taking the time.
Thank you so much for having me.
All right, everybody, that's all we have for you right now here on Sidebar. Thank you so much for joining us. And as always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.